if you're hurt in an accident and negotiating with an insurance company over what you deserve, you want to know all the information that can impact the amount of money you get. Our legal expert, Phil Harding, is here today and every Friday to answer your questions, especially those about money, because everybody cares about their money, of course.
They do.
Yeah, and today we're continuing our law school for the lay person. Phil, let's take a second to remind viewers about your resume and how much experience you have, because you have a lot. You're our legal expert. You were named super lawyer. I love that again this year. Your expertise was sought out by USA Today on the Aurora shooting. Also for Newsweek, you were named one of the top attorneys in Colorado. That's great.
Yes.
And you teach law school, right?
Well,
you
I teach lawyers.
You teach lawyers.
right.
And what's the class called?
Well, it's attorneys have to do this thing called CLE, stands for Continuing Legal Education. And I've done PI 101, which stands for Personal Injury 101, and I teach them how to handle cases like this.
That's great. And so what you do is you take your expertise from teaching them and bring it onto television, so we're a little more educated if we have to go to court. So what are we talking about today?
Well, I know it sounds boring, and I know it, and it does,
What?
and you're laughing.
No,
but,
I'm totally interested.
Okay, all right, and so here's the great part about it. We are going to be talking about the Colorado and federal rules of evidence, and I know it sounds boring, but don't change the channel. Really, it's like you're tuning in to know the time, and I'm telling you how to build a watch. But once you know how to build this watch with these rules of evidence, you absolutely can either use this in court, like if you have a traffic ticket. Or even more important, this will give you more money on a settlement.
Yeah.
And so let's talk about that.
Yeah, let's talk about getting more money.
Let's talk a little bit about, I get these questions from viewers, and I love going over that. And so one of the viewers called in to me and said, hey, I want to talk a little bit about a case. And the case that I want to talk about is they were injured in an auto accident. And the person that ran into them either didn't have a license or was drunk, and the insurance company had offered $10,000 to settle it. And then they say, why don't I just go to trial? And I can present evidence that this $10,000 was offered to me, and the trial judge is going, or jury is going to give me so much more money because they're going to realize that's not fair. I'm going to bring that up.
But is that really the case? Does the jury end up doing that?
Well, here's the thing. This gets into really our first rule of evidence, not our first, but it's called Rule 408. And it says, essentially, that evidence of the following is not admissible on behalf of any party. Promise seen to offer valuable consideration to compromise the claim. In other words, offering money. Or number two, conducts or statements made in compromise negotiations. So anything that's said during a settlement negotiation, like, I'm really sorry what took place, we're going to offer you $10,000 on that. That cannot come out in trial.
Why?
Isn't that weird?
Why is that?
Well, the reason why is courts would much rather have two parties work out their differences and design their own settlement, because then they're happy with it. Whereas if they go to trial on this thing and the court rules upon it, then only one person is happy. And usually when you get a ruling, no one's happy. So the judges and the courts make this rule in effect so that anything said, anything that goes on will not be admissible. Which brings up a very interesting question. And the question is, and I want to talk about this. People say, so anything that's mentioned in a settlement negotiation is not admissible? And my answer is, yes, no, probably not. Because even though they might say, hey, it was my fault, and you can't go during trial and say, remember in the settlement negotiations, you said that it was your fault, they can bring it up another way. But now let's talk about something else. I want to talk about Rule 402. And essentially what it says is all relevant evidence is admissible. And let's talk about that, for example. What that means is when someone is in a car wreck, and let's say the person is drunk, and this is what people are shocked at. A lot of times, the person that injured you, if they were drunk, doesn't even go in front of a jury, and the jury doesn't even know about that. And let me tell you why.
Yeah, I would like to know why. Because,
isn't that weird? I mean, there are a few exceptions, but here's the story. What will happen is the other side, the insurance company, is going to say, we admit we're at fault. So now it's no longer about what caused the accident, but how much someone is injured. So even though under 402 it's relevant, right, that we just saw, the only thing that can happen under 402 is that this is about damages. Now I want to talk about Rule 403, Okay?
Okay.
Now, 403 is important here. And 403 says that, let me go to my graphic, although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Now, let's talk about this. So, under 402, someone may be drunk, and that's relevant information, right, to a jury. But once the other side accepts liability, that probative value, what that means is the value of that evidence is so outweighed by an unfair trial to the defendant. Now let's talk about that. Doesn't that, it sounds confusing.
Right.
But here's the story. Under all of this, under 402 and under 403, when you're talking to the insurance company, go into it. And if they accept liability, don't go into stuff that's not going to be admitted in a trial, like someone was drunk or there's insurance. And I got to tell you, during trial, if you mention insurance at all, that's a mistrial. So what happens is talk about how much you're injured. Talk
Okay.
about that. We learned about 402, 403, 408, and under 411, it says no insurance can be admitted during trial. Sounds
right.
confusing, but it's not.
Sounds confusing. You'll have to replay this one and call Phil Harding, Harding & Associates. If you have any legal questions for Phil, he wants to hear from you, just log on to coloradosbest.tv. Look for his photo and click there. You can submit your legal questions, and he takes the time to answer them personally. He might even address your question right here on Colorado's Best. If you would like to contact Phil at his office, Harding & Associates, the number's 303-762-9500, or you can catch them online at hlaw.org. Well, coming